Hello, everyone, and welcome to Uncivil Law. All right, for today's stream, we are doing something a little bit different. We are going to cover Texas's new law relating to abortion. Now, I want to make very clear what we are going to do and what we're not going to do here, okay? So right off the bat, I want to make clear that we are not going to be discussing pro-choice versus pro-life in general. We're not going to be discussing what it does or does not ban. And we're not even going to be discussing whether or not what Texas tries to ban would be compatible with either Roe versus Wade or Casey versus Planned Parenthood. Those are all interesting questions, but not the question we're here to decide. Not for the least of reasons that the Roe and Casey portion of this will be answered, at least in part, when the Supreme Court takes up the ban that's currently being appealed from Mississippi. So some of that is yet to be decided. Instead, what we're going to be focusing on is some really, really brilliant language that Texas put in terms of its enforcement mechanism to try to get around some of the problems that other states have had in the past in trying to enforce their various versions. So Texas has learned from the misfortunes of others and has crafted some unbelievably brilliant language to try to evade legal review and try to circumscribe legal review and make it much more difficult than it would normally be in a normal case. So that's the things we're going to be talking about from the Texas's bill. The things that change the enforcement mechanism, because the other stuff goes to, the what is legal and what's not. But how they want to try to enforce it is much more interesting in my view. And it's a legal education channel, so let's talk about what's legally interesting, right? Great. Now, so we're going to pick up midway through the bill. So previously in the bill, we declared what was illegal and what was legal and how doctors have to do this, documentation, blah, blah, blah. Call it all that stuff, all right? So we're going to pick it up in the middle of the story with Section 171.207, limitations on public enforcement. Notwithstanding 171.005, which is the law that we just passed just now, or any other law, the requirements of this subchapter shall be enforced exclusively through the private civil actions described in Section 171.208, which is coming up in a bit. No enforcement of this subchapter and no enforcement of Chapter 19, which deals with homicide, and Chapter 22, which deals with sexual assault, of the Penal Code in response to the violation, in response to this subchapter. So you can't use homicide law or sexual assault law to prosecute anyone criminally, okay? May be taken or threatened by the state, a political subdivision, a district or county attorney, or an executive, or an administrative officer or employee of the state, or a political subdivision against any person except as provided by law. All right, so that was a whole lot of stuff that I have to unpack to describe, because this is where the brilliance starts. Okay, so Texas made a law that banned abortion. And then in Section 171.207, they said no state authority can enforce this law. That's what that says, by the way. That's the short version of that. No state, local, county authority of any description may enforce this law. You may not enforce the law that we just passed just now, and you may not try to prosecute someone for either homicide or sexual assault based on anything in this law, okay? So this doesn't modify homicide law. This doesn't modify sexual assault law. And so you can't use those mechanisms, and no state authority, local government, any state official of any kind can enforce this law, right? It's brilliant. It's absolutely brilliant. And here's why it's brilliant. Here's why the state's doing this. Okay. Normally, if you want to file a suit to stop this kind of law, you'd bring a pre-enforcement challenge, right? You would be suing the Attorney General, and you'd be saying, "Hey, Attorney General, you can't enforce this law. I haven't broken this law yet, but basically I'm planning to in the future, and you can't enforce that law against me." So that's normally how this gets brought up in court, right? As a pre-enforcement challenge. People sue the Attorney General, the law gets argued over in court, the Attorney General is barred from enforcing the law, yada, yada, yada. Well, they can't do that. That's why this is brilliant. They can't sue the Attorney General because the Attorney General has no power to prosecute them. They're a state official. So they can't say, hey, they can't go to court and say, hey, Attorney General, you have no power to prosecute us, because the Attorney General would just be like, you're right. I have no power to enforce this law. So there means there's no credible threat from the Attorney General or any other state authority. So you can't say, hey, DA, or hey, county attorney, or hey, anyone, you're going to threaten me. No, you can't bring a pre-enforcement challenge. That's why it's brilliant, because the state takes themselves out of the equation. There's no one in the state to sue. You can't sue the governor, you can't sue the Attorney General. There's no one in the state to sue, because no one in the state has power to enforce this law. That's what makes it so brilliant. Okay? Then they go on to say, subsection A may not be construed to legalize conduct prohibited by law, and that subchapter deals with the abortion of a baby while it's being born. There's a specific law for that. In the process of being born, you can't do an abortion. That's Title 71, Chapter 6.5 of the revised code. Limit or any way the availability of a remedy established in 171.28. We haven't gone that far yet. Or limit the enforceability of any other laws that regulate or prohibit abortion. So if there's some other law that regulates abortion in some other way, right, those laws remain on the books. This law doesn't touch that. It doesn't enhance it. It doesn't remove it. Those things are still in place, okay? All right, so next thing up. Here's where the enforcement mechanism comes into place. 171.208, civil liability for violating or aiding and abetting a violation of subperson A. Any person other than an officer or employee of a state or local government entity in the state may bring a civil action. So basically, effectively, we have deprived the elected Attorney General of all power, and we've enabled every person individually to be a private Attorney General, right? Because you're not suing for a harm that's occurred to you, right? That would be like a typical lawsuit, right? You've harmed me, so I'm going to bring a tort action for your harm against me, right? No, in this case, you're saying you have violated the laws of the state. And the state can empower people other than the Attorney General to enforce its law. California does it all the time. They have a Private Attorney General's Act for exactly this reason. Now, in California's version, the normal Attorney General still has power too. It's just a supplement. But in Texas's version, the private Attorney General, that is to say, any random individual, is the only person who can bring this action. So any random person can bring a lawsuit on behalf of and in the name of the state. And you don't know who that person is because, it could be anybody. So who can you go pre-enforcement after? Nobody, right? So that's how we're solving that problem. We're giving every individual person the power to bring a lawsuit on behalf of and in the name of the state of Texas, but deprive the Attorney General of the power. So what kind of lawsuit can they bring? A civil lawsuit against any person who performs or induces an abortion in violation of this subchapter, knowingly engages in conduct that aids or abets in the performance or inducement, including paying for or reimbursing the cost of abortion through insurance or otherwise, if the abortion is performed or induced in violation of the subchapter, regardless of whether the person knew or should have known the abortion would have been performed or induced in violation of this chapter. So merely aiding and abetting, even if you didn't know that they were going to be doing it, is enough. You're part of the conspiracy, a conspiracy that you don't even know of. So we're modifying conspiracy law, right? Intends to engage in conduct described by subsection 1 or 2. So we can go after anyone who's doing it or after anyone who's planning on doing it. So you can sue abortion providers before they do it, but they can't sue you because they don't know who you are. Subsection B, if a claimant prevails in an action brought under this section, the court shall award injunctive relief sufficient to prevent the defendant from violating this subchapter or engaging in acts that aid or abet the violation. So you must give injunctive action if any of the defendants ever win. or any of the plaintiffs ever win. So that's why it's really brilliant, right? That's why it's really brilliant, because instead of the attorney general or the county attorney or the district attorney bringing it on behalf of the state and, failing, and then, you'd have res judicata, right? Because it's the same people trying to bring the same lawsuit over and over and over again, right? So you can't do that, right? So if it was the attorney general or the district attorney or someone who was bringing the lawsuit and they lost, it's res judicata. They can't just bring another lawsuit against someone else. But we don't have that problem now, because we've empowered literally everyone as a private attorney general to bring their lawsuit. So even if one plaintiff loses, well, they're out of the game, maybe res judicata against them. But hey, any other person can bring it, and it's not res judicata against them because they weren't a party in that other lawsuit. Right? I'm not a party in that other lawsuit, so the lawsuit can't impact me, right? So whatever decisions over there might bind those parties, but has no binding over me. So all you need is one plaintiff to be successful. And that's why that's brilliant, because it prevents decisions that favor the defendant from being used in the future. And all you need is one plaintiff, and then you have injunctive relief, and then binds everybody. It's really clever. Statutory damages in amount not less than $10,000 for each abortion defendant performed or induced, and for each abortion performed or induced in violation defendant aided or abetted. So not less than $10,000 of damages for every abortion that was performed, or anyone who aided and abetted, anyone who gave any sort of help. So everyone who drove the person to the facility, or everyone who provided money for a hotel room, or anyone like that, right? We can go after each person individually, and each person individually is liable for not less than $10,000 minimum. And because it would always be someone of this state bringing the lawsuit, right? It would be a Texas person bringing a lawsuit against a Texas abortion clinic. So you can't take it to federal court because you don't have diversity jurisdiction, right? So it has to stay in state court. You see why all this is being thought ahead? They're thinking about everything, man. And also they get costs and attorney's fees. So anyone who tries this can get their attorney's fees paid for. Notwithstanding subsection B, a court may not award relief under this section in response to a violation of A1 or 2 if the defendant demonstrates defendant previously paid the full amount under subsection B2 in a previous action for that particular abortion. So if you've already paid for one, how about the rest of them? Or for particular conduct, how about other conduct? Notwithstanding Chapter 16 of Civil Practices and Remedies, a person may bring this action under this section not later than the 4-year anniversary of the cause of action. So, whatever the statute of limitations is normally in Texas, and I think it's 2 years, right, for a civil cause of action, well, the legislature says, how about 4 years? How about 4 years? So you can go back, and this would allow you to go backwards, and it would allow you any time within 4 years to bring a lawsuit for any abortion against any person who aided or abetted or did the abortion themselves. So you could go after the abortion providers, you could go after people who drove them, you could go after people who gave the hotel rooms, you could go after people who paid for meals, right? You can go after all kinds of people up to 4 years later. They're thinking ahead, man. JG says, someone tell me how this is a good thing. JG, that's not what I'm here to do. I'm not here to tell you it's good. I'm here to tell you it's legally brilliant. It's in the description of the video. I'm not here to tell you it's good or bad. You can have any opinion about whether it's good or bad. I'm here to describe how it works mechanistically. I'm here to describe why it's legally brilliant. At no point in this exchange so far have I said it's good or bad. I'm just saying this is what it's trying to do. This is why it's trying to do it. This is why it's brilliant. You can decide for yourself whether it's good or bad. Notwithstanding any other law, the following are not a defense to this action. So you cannot use the following defenses in a potential civil suit. Ignorance or mistake of law, which wouldn't work in criminal case, but we're just going to throw that in for civil case too. So you can't say, oh, I didn't know. A defendant's belief the requirements of the subchapter are unconstitutional or were unconstitutional. Now, please take note, this is worded in a way to make clear that what you can't say is, this is going to like the mens rea sort of element. You can't use a defense of my individual belief of it. That it is unconstitutional is different than my belief in it. So it's not an argument that it is unconstitutional. That's still allowed. You can still make the argument it is constitutional, but you can't make the argument that I believed it was unconstitutional. Okay, so there's some nuance there. JG says, I know, but I was asking what you think. But JG, I'm not here to tell you what I think. I'm here to tell you it's right in the title, JG, that it's legally brilliant. All I'm trying to do is, at this moment, is try to convince you why it's legally brilliant. I'm not here to tell you it's good or bad, so I refuse to state an opinion other than it's legally brilliant. You can think for yourself. A defendant also cannot rely on any court decision that has been overruled or appealed by a subsequent court, and this is a nice little kicker, even if the court decision had not been overruled when the defendant engaged in conduct that violates the subchapter. So if there's a decision somewhere from some inferior court that tells you, oh, this is okay, and you rely on that, and at some later point it gets reversed, you can't rely on that court decision because it hasn't become truly final yet, because it could still be appealed. So this is telling you you can't rely on a decision that still hasn't gone through the entire processes of it. So that's pretty really interesting there. A defendant's reliance on any state or federal court decision that's not binding on this court when the action has been brought. So you can't rely on any state decision that would not be binding on the relevant court. So, for example, in Texas, like many places, the courts of appeals are geographically split, which makes more sense for Texas than most states, but still. So not every decision that's appealed goes to the same court of appeals. They go to different courts of appeal. And they have jurisdictions, territorial jurisdictions, kind of like the federal courts do. And so it says, well, if the appellate court for whatever issued a decision, if that's not the appellate court for you, you can't rely on that either. You have to get one of your own from your own appellate court. So trying to compartmentalize that. Vindictius Prime says, the brilliance of this legislation turns everyone to Karen. Vindictius Prime, the brilliance of the legislation is that it's trying to overcome problems that the legislature has had in the past with other versions of this in their own state and other states. It's brilliant because it prevents pre-enforcement remedies. It's brilliant because it neuters the effect of res judicata by spreading it out among multiple people instead of through a single chain. It's brilliant because it extends for a longer period of time and goes to aiding and abetting instead of statutory minimum fines. It's brilliant. It's brilliant for trying to overcome the things that have made these kinds of laws unable to be enforced in other states. It's brilliant for its mechanistic qualities. You also can't defend based on non-mutual issue preclusion or non-mutual claim preclusion. So issue preclusion would be basically res judicata, to put simply. And so basically that's saying non-mutual, right? Non-mutual, right? So if it's me and the abortion clinic, if I'm suing, that's the same person, right? Mutual. But if someone else comes in, right, you can't say, oh, that issue's been decided. with respect to this other guy. No, because that's not mutual with respect to you. So you can't use any judgment in any other case to defeat your liability in the case that's before you if it's being brought from some other different person. The consent of the unborn mother. So the consent is irrelevant, which, kind of you could take that as a given. Any claim the enforcement of the subchapter or the imposition of civil liability against the defendant will violate the constitutional rights of third parties. So you can't say, well, third parties will be harmed. No, you can't do that. So they're just trying to take away, like all these defenses. They're trying to neuter res judicata. They're trying to neuter issue preclusion. They're trying to neuter claim preclusion. They're trying to increase liability against a whole number of people. And they're trying to, by making it not available to state actors, they're preventing pre-enforcement challenges. And then even if you're successful with respect to one person who brought the lawsuit, another person could bring the exact same lawsuit. The way this is written, an infinite number of people could bring the same exact lawsuit over and over and over again with respect to the same child. That's what's brilliant about it, the way it's written, right? So if we have aborted fetus A, right? If we have aborted fetus A from abortion clinic A, and plaintiff A comes in and says, hey, you can't do that, and the judgment goes against them, well, what about plaintiff B, C, D, E, F, G? And the clinic can say, wait a second. Person B, C, D, E, F, G can't sue me. Person A already sued me, and I won. And they thought about that. Oh, no, you can't do that because it's non-mutual issue preclusion. Yeah, you have that locked up with person A. You have that locked up with person A. So person A can't bring that lawsuit again with respect to the same child. They can't do it, but anyone else can. Anyone else can bring it infinitely. And you have to win them all, because if you ever lose one, you'll get an injunction. Right? So you're spreading it out. And you say, oh, I have res judicata. Not with respect to this guy, you don't. It's brilliant. And not with respect to fetus B, and not with respect to abortion clinic B, and so forth and so on. It's brilliant for trying to make this some sort of death by a thousand cuts nightmare. Runkle of the Bailey says, this seems like they're willing to throw out the rule of law entirely in order to push the ban through. No, not really. Not really. There's nothing obvious, right? There's a whole bunch of things that we normally think of, but that are not necessarily required. Like the idea that a judgment involving someone else should impact me is not inherently obvious, right? Because it's not me, right? I didn't have a chance to do that, right? So it's like, why shouldn't I have a chance to go at it? So are they abridging the rule of law? No, they're just constraining res judicata to only the people involved. I mean, only those people had their day in court. How about other people? How would anyone have standing once they're sued? Oh, how does anyone have standing? You mean in order to bring the case? How does any plaintiff have standing? Oh, it's easy. It's easy because they're all private attorney generals. That's how they have standing. They don't have to show any harm to them. That's what's brilliant about it, right? They don't have to show any harm flowing to them. The reason they have standing is because they're suing on behalf of the state. Yeah, that's where there's the private attorney general. So they're bringing the state's cause of action, don't you know? And because I'm not a state actor, right? So I can bring it because I'm defending the state, but because I'm not a state actor, right, I can't impute to everyone else. The way, like, if I were another state actor, I could. Like, if some state actor brought it and then another state actor did it, like, they'd all impute each other. But because I'm a random guy and he's a random guy, even though we're both acting in the name of the state, I can't bind him and he can't bind me. So that's how they have standing. because they're all private attorney generals able to sue on behalf of the state. Shouldn't the cause of action be done by the state? JG, we covered this earlier in the case. We covered this earlier in the claim, or earlier in the bill. The bill very specifically and very deliberately strips all state actors of any ability to bring a lawsuit under this bill. I'll even go back up because we're only on page 2, but yeah. So where are we right now? We're on subchapter F on defenses. Yeah, it's right here in section 17171207. The requirements of this subchapter shall be enforced exclusively through private civil action. No enforcement of this subchapter and no enforcement of the criminal law in respect to violations of this subchapter may be threatened or taken by the state, a political subdivision, a district or county attorney, or any executive or administrative officer or employee of the state or a political subdivision against any person. So they stripped all state actors from being able to bring a lawsuit here in order to avoid pre-enforcement challenges. It's brilliant. Subsection F. It is affirmative defense if a person sued under subsection A2 reasonably believed, after conducting a reasonable investigation, the physician performing or endorsing the abortion had complied or would comply with the subchapter. So if they performed abortions that are still legal under this law, because it doesn't ban all abortions, just any abortion in which a heartbeat can be detected. A person under the subsection reasonably believes that the physician performing it will comply with the subchapter. The defendant has the burden of proving an affirmative defense. So it's not the plaintiff that has to prove lack of affirmative defense. The defendant has to prove affirmative defense. So we put the burden of proof, burden of the production of the affirmative defense onto the defendant. Nice touch. This section may not be construed to impose liability on any speech or conduct protected by the First Amendment, as made applicable to the states. So you can still march against it and stuff, knock yourself out. Notwithstanding any other law, this state, a state official or district attorney may not intervene in an action brought under a section. So they went even so far as to say, well, to prevent it from you trying to use, because the word intervene here is being used in a technical sense. So there's something actually called intervention where basically you can force your way into someone else's case. It's rare, but there are rules for it, right? So if you're a proper intervener, you can force yourself into it. So it's this is an A and B conversation, see yourself out, and C says, how about no? Now it's my lawsuit too. That can happen. But they said specifically, yeah, you can't do that. So they can't intervene. But what they can do is file an amicus curiae. So they can file a friend of the court brief, which, might be used, for example, by the one of the parties for ideas, for example. Just, here's some thoughts you might want to use. Can you lawfully craft a law such as this? Seems they're trying to limit due process. This is all civil law, remember? There's no criminal penalties in any of this. So the due process requirements are a lot lower because all that's available is civil remedies. You can't go to jail for this. Notwithstanding any other law, a court may not award costs or attorney's fees to a defendant. So the defendant may not get attorney's fees. But the plaintiff can, but not the defendant. So it's a one-way fee shifting statute. Notwithstanding any other law, civil action in this section may not be brought against a person who impregnated the abortion patient through an act of other acts. So you can't. Okay, so yeah, the person who did that can't bring the cause of action. So, okay, we were thoughtful enough to exclude one person who can't sue. The one person who can't sue is someone who caused the pregnancy through an illegal act. So we were thoughtful enough to prevent that. So there's that. How it work if they made a law that criminalized a certain action but only allowed to be privately prosecuted? I don't know. But since I don't have that hypothetical, I don't have to worry about it right now. Fatsy said, didn't you read that if the person paid the fine, they would not be liable again for that event? Yes, I did read that section. I don't think I said anything different than that. If I did, maybe I misspoke. But yes, once they paid with respect to a particular action, they wouldn't be on the hook for that particular action again. That's true. So there is, I guess, res judicata. But the problem is it's like a one-way res judicata. When the defendant wins, there's no res judicata. There's only res judicata when the plaintiff wins. That binds future things. So, but yeah, it's like there's a lot of these like little one-way ratchets in here. That's very interesting. Section 171209, undue burden defense limitation. A defense against whom an action is brought does not have standing to assert the rights of a woman seeking abortion as a defense. So, unless, okay, so this would be for like the abortion clinic, okay? So this is dealing basically with third-party standing, okay? So this isn't the woman, this is the abortion clinic. So a defendant whom the action is brought against does not have standing to assert the rights of the woman. The woman has the ability to assert her own rights. Surely, of course, for whatever it's worth against all the people who want to sue her. But yeah, sure. But the abortion clinic, this is really meant to go for the abortion clinic. The abortion clinic can't stand up for the woman, third-party standing. They're trying to limit third-party standing, which, should be fine. So unless the U.S. Supreme Court holds the courts of the state must confer on defendant to assert third-party rights as a matter of federal constitutional law, good luck with that. Defendant has standing to assert the rights of women seeking abortion under the test for third-party standing established by the U.S. Supreme Court. So they are saying you cannot sue for third-party standing unless the U.S. Supreme Court itself has said you can. And the third-party standing rules from the U.S. Supreme Court are, pretty tight. A defendant in this action may assert an affirmative defense to liability if the defendant has standing to assert third-party rights of women or group of women seeking abortion in accordance with the law, and defendant demonstrates relief sought by the claimant will impose an undue burden on that woman seeking the abortion. So they can say, oh, well, we have affirmative defense to liability, but only if we have standing in third party. So otherwise, not so much with the third party standing. Can they eat the Court of Appeals jurisdiction like that? Within their own state? Sure. Yeah, within their own state, yeah. I mean, they have to give someone the right to appeal. But they didn't even eat the Court of Appeals jurisdiction. They just limited the scope of the decisions of the Court of Appeals to within their own geographic turf. They more tightly limited them than normally would be the case, which they can do with their Court of Appeals. So sure, I don't see any problem here so far. I think it's brilliant. I feel like the Supreme Court would throw this case out before even getting to the abortion. The U.S. Supreme Court is highly unlikely to hear a case coming out of this. There's no way to get to federal court except once the Texas Supreme Court. Well, actually, it's not the Texas Supreme Court because they do criminal cases, right? It's the Texas... What's the other one called? Is it called the Court of Appeals? No. We have two Supreme Courts in Texas, one for criminal law and one for civil, for some reason. So it's not the Texas Supreme Court, it's the other one. Anyways, but it wouldn't be unless the not Texas Supreme Court other one rendered a decision and you got a writ of certiorari. And why would the Supreme Court ever take this on a writ of certiorari? I don't see that happening, man. They've basically neutered any ability to go to federal court over it. It's great. I mean, someone will try, but of course, if you do go to court, the Fifth Circuit Court of Appeals will whack you over the head. The Fifth Circuit Court of Appeals is gonna... They'll let this fly. I see it happening already. Texas Court of Criminal Appeals. Okay, so I had it right the first time. Texas Court of Criminal Appeals is for criminal. Texas Supreme Court is civil. So it would be Texas Supreme Court. Yeah. A defendant may not establish an undue burden under the section by merely demonstrating an award of relief will prevent women from obtaining support or assistance, financial or otherwise, from others in their effort to obtain an abortion. So it's not an undue burden merely because you can't get money from others to engage in your wish for an abortion. Arguing or attempt to demonstrate the award of relief against other defendants will impose an undue burden on women seeking abortion. So you can't say it's an undue burden to you because of damages that are happening to some other person. So it's basically a standing thing. I could see Supreme Court taking this up on res judicata. I don't see so, man. I don't think so. I think that this works. I mean, someone's going to try, but it's a lot of years from now, and I don't see it obviously. Because what the Texas Supreme Court is saying, what the Texas legislature is saying, is that a case only binds its own parties and doesn't extend beyond that, which, seems compatible with due process, even if it means in practicality. I mean, if 3,000 people have the same cause of action against a common defendant, then they can all bring causes of action independently, and they might all go to juries independently and come up with different answers. So, it works. It could work. Res judicata was read into the Constitution from full faith and credit clause. I don't see a full faith and credit clause. Are you just making up statutes? Are you just making up things at this point, Matt? Because that irritates me. Full faith and credit clause of the Constitution means that the acts of one state have to be honored by another state in terms of their judicial decisions. That's full faith and credit. This is all internal to Texas. There's nothing about a judgment of... There's no full faith and credit analysis in this whatsoever. Full faith and... What are you talking about? You're acting as a state, so it's not really a different party. Yes, it is, Matt. It really is. Look up, if you don't believe me, look up the history of California's Private Attorney General Act. All right. The affirmative defense under Subsection B is not available if the United States Supreme Court overrules Roe v. Wade or Planned Parenthood v. Casey, regardless of whether the conduct or the action was based occurred before Supreme Court or not. So if the Supreme Court overrules Roe or Casey, then, yeah, you're screwed. Which, fair enough. Nothing in this section shall in any way limit or preclude a defendant from asserting a defendant's personal constitutional rights as a defense to liability. So you can assert your own rights, right? And that's different than your belief in it, which is a point I tried to make earlier when we talked about that, right? I tried to make this point earlier, but I'll make it again. Because the language of the statute says you can't use as an affirmative defense your belief that it's unconstitutional. But you can use the reality of its unconstitutionality. So you can't go in and say, well, I believe it to be unconstitutional, therefore affirmative defense. No, that's not going to work. But you can say, well, it's not my belief, but the reality of it, and that's a different issue. So that's also just kind of reemphasizing that point here. Civil liability venue. A civil action may be brought in the county in which all or part of the acts occurred, county of residence for any one of the natural persons, county of the principal office of any one of the defendants, county for residence of claimant if the claimant is a natural person. That all seems fine, fair enough. If civil action is brought in any one of the venues, action may not be transferred to a different venue without consent. So no shifting of venue. I'm not sure why you necessarily would want to, but you can't. Sovereign, governmental, and official immunity. This section prevails over any conflicting law, including the Uniform Declaratory Judgments Act and Section 37 of Civil Practice. So yeah, we are creating a whole new thing unto itself in its own little universe. So we are abrogating all that stuff, which of course we have the right to do because we're the Texas legislature, so we can do that, so not so much. The state has sovereign immunity, a political subdivision has governmental immunity, and each officer and employee of the state or political subdivision has official immunity in any action, claim, or counterclaim, or any type of legal or equitable action that challenges the validity of any provision or application of this chapter on constitutional grounds or otherwise. So just in case you wanted to sue us, you can't, because we are definitely making sure we have all the immunity possible. So assuming that we otherwise abrogated it somewhere else, not so much. So everyone has immunity. All the state officials have immunity. A provision of state law may not be constituted to waive or abrogate the immunity unless expressly waived under this section. So assuming you can find some other law somewhere else that abrogates our immunity, we're unabrogating it, just to give ourselves all the immunity possible. So just in case you're thinking about suing us anyway, you can't, because we're immune. So suck it. Now, this is really fun. In the severability clause, this is really interesting stuff, what they have severability here, okay? Mindful of Leviat versus Jane L., the severability of a state statute regulating abortion, the United States Supreme Court has held that an explicit statement of legislative intent is controlling. So there was a case from Utah which dealt with this issue about whether or not, once a part of the law was struck down, whether or not the remainder of the law survived or not. And that's often a challenge, right? So it's like, you want to strike part of the law, does the rest of the law remain? So there's a whole bunch of things that courts do too. But courts only do those things as the legislature doesn't tell them, right? So because the legislature is, after all, master of its law. And severability deals with the question of what would the law look like if the legislature had known it was illegal in the first place. What would they have done? Now, normally the courts have to speculate about what the legislature would have done. It's like, well, would they still have passed that law? Would they still have passed that or not? I don't know. But fortunately, Texas has you covered, because they're going to tell you. They're going to tell you, hey, future court, in case you're ever asking yourself, what would the Texas legislature have done? We're about to tell you, okay? It is the intent of the legislature that every provision, section, subsection, sentence, clause, phrase, or word in this chapter, and every application of the provisions in this chapter are severable from each other. Well, that's basically all the things, right? So just in case you're wondering if it's severable, yes, you can sever anything. The word, the sentence, the clause, the part, whatever, everything is mutually severable from everything else. So you can't say, well, we severed this and therefore the statute falls. Nope. It's all mutually severable down to the word. Okay, that's pretty clear. If any application or any provision in this chapter to any person, group of persons, or circumstances is found by a court to be invalid or unconstitutional, so what if some future court says we did it bad? Well, the remaining applications of that provision to all other persons and circumstances shall be severed and may not be affected. So that's basically, again, trying to limit res judicata, okay? So if for any person or group of persons or circumstances, any court finds it to be unconstitutional, it's only unconstitutional for that person, group of persons, or circumstances. So again, this is trying to limit the ability of cases to read on other cases. It basically, this is the rough equivalent of making every one of these cases non-precedential. Right? There's all sort of islands unto themselves. They're all non-precedential. So basically, we've abrogated the concepts of common law for this thing. That's how deep we're going. That's how deep. So just because some person or group of persons is unconstitutional as to them, well, that's interesting and all, but that's a non-precedential opinion. That's basically what that says in so many words. So it might be unconstitutional as to them, but maybe it's unconstitutional. Maybe someone else can give it a go, right? So this is the death by 1,000 cuts. It's like, oh, Planned Parenthood of Austin won that lawsuit. Hope they can win the next one and the next one and the next one and the next one and the next one. Oh, what's unconstitutional? Oh, I hope they can win the next one, next one. Maybe the court will say something different. Yeah. All constitutionally valid applications of this chapter shall be severed from any applications the court finds to be invalid, leaving valid applications in force, because it's the legislature's intent and priority that valid applications are to stand alone. So anything invalid, all the rest of it remains. Even if a reviewing court finds a provision of this chapter to impose an undue burden in a large or substantial fraction of relevant cases, the applications that do not present an undue burden shall be severed from the remaining applications. So even if there's some undue burden in some cases, how about the other cases? Those can all be severed, and they remain in force and shall be treated. They shall be treated as if the legislature had enacted a statute limited to the person, group of persons, or circumstances for which the application does not present an undue burden. Well, that's really just thinking all the way ahead now, isn't it? That's just thinking all the way ahead. It's like, if you find a person or group of persons or some circumstances that's undue, all right, the legislature, please take note, the legislature would have enacted the law with the other people in mind. So we are telling you affirmatively that if you say, well, as to these group of people, what about the rest of the people? The legislature is telling you, affirmatively, we still want it valid to all the other people. So it's all about compartmentalizing. This is shrinking the scope of cases and making them all non-precedential, basically, and shifting the scope. So it's like, well, we have to throw out this word. Oh, that's no problem. We have to throw out for this group of people. Oh, that's no problem. We can endlessly patch this thing because the legislature told us we can. And all that's perfectly valid because the legislature is master of its law. They can make statements like this. So this is just brilliant stuff right here. If any court declares or finds a provision of this chapter facially unconstitutional, good luck with that, incidentally, when discrete applications of that provision can be enforced against a person, group of persons, or circumstances without violating the United States Constitution and Texas Constitution, these applications shall be severed from all remaining applications, and the provision shall be interpreted as if the legislature had enacted a provision limited to the person, group of persons, or circumstances which the provision's application would not violate our constitutions. The Texas legislature is now telling you about legislation in the alternative. The legislature further declares it would have enacted this chapter and each provision, section, subsection, sentence, clause, phrase, or word, and all constitutional applications of this chapter, irrespective of the fact that any provision, section, subsection, sentence, clause, phrase, or word, or application were declared unconstitutional or to represent undue burden. So we would have enacted this to the absolute maximum extent that it was constitutional. So if you find anything unconstitutional about it, we would have enacted this statute with the maximum extent allowed. If any provision of this chapter is found by any court to be unconstitutionally vague, the application of that provision that do not present a vagueness problem shall be severed. No court may decline to enforce the severability requirements of the statute on the ground that severance would rewrite the statute or involve the court in legislative or lawmaking activities. So that's another thing that courts will often do. It's like, well, once we sever it, we can't fix this because, if we did, we'd be acting as a legislature. We can't do that. And the legislature tells you, yes, you can. You can't do that, court. You have to obey the law. And our law is, hey, court, you can't do that. You can't say, oh, we can't fix it. Yes, you can. Because we're telling you you can. A court that declines to enforce or enjoin a state official from enforcing a statutory provision does not rewrite the statute, as the statute continues to contain the same words as before the decision. So, Yeah, you are not rewriting the statute because the statute still says exactly the same thing it did before. It's just that you're constraining it in some ways. So, hey, you can put as many holes in this as you want, and we want the rest to still float. A judicial injunction or declaration of unconstitutionality is nothing more than an edict prohibiting enforcement. But that may be subsequently vacated by a later court if that court has a different understanding, which that's fair enough. That's kind of true. A declaration of unconstitutional can always be vacated by another court. It's not a formal amendment of the language, and no more rewrites the statute than the decision of the executive not to enforce the statute in a limited defined set of circumstances. So, in the same way that an executive could, in some other realm, not enforce the statute, it wouldn't change the wording of the statute. Right? The statute's still the same no matter what the executive does. So in the same way, hey, court, you're not rewriting our statute. Don't worry about it because you can't. It's going to be the same no matter what you do. So yeah, that's really awesome. Are there no 14th Amendment Equal Protection Clause amendments? Not that I see. Not immediately obvious. Award of attorney's fees. Notwithstanding any other law, any person, including an entity, attorney, or law firm, who seeks declaratory or injunctive relief to prevent this state, a political subdivision, any governmental entity or public official in the state, or any person in the state from enforcing any statute, ordinance, rule, regulation, or any other type of law that regulates or restricts abortion, or that limits taxpayer funding for individuals or entities to promote abortions, and any state or federal court, or represents any litigant seeking such relief, is jointly and severally liable to pay the cost of fees of the opposing party. So, hey, people are planning on suing us. You have to pay our fees if you lose. For the purposes of this section, a party is considered to be a prevailing party if the state or federal court dismisses any claim or enters a judgment. Regardless of whether a prevailing party sought to recover costs or attorney's fees in the underlying action, a prevailing party under this section may bring a single action to recover costs and attorney's fees that sought declaratory injunctive relief not later than the third anniversary of the date. So, just in case somehow you forgot to ask for attorney fees when you sued, we are going to let you effectively amend your complaint up to 3 years after judgment to ask for attorney's fees. So the court has to let you make that motion for attorney's fees through up to 3 years late. So we're like basically radically augmenting the time periods that courts normally consider things to be timely in because it's our law and we can do whatever the hell we want. So it's timely if you do it anytime within 3 years of the original file. It is not a defense to an action under this subsection C that a prevailing party failed to seek recovery costs in the underlying action. So you can't defeat the lawsuit that says, I want money from you because in the original lawsuit they failed to ask. And they should have, so that would be basically like waiver. So basically you can't argue waiver. It's non-waivable. The court in the underlying action declined to recognize or enforce requirements, or the court in the underlying action held any provision or invalid, notwithstanding the doctrines of issue or claim preclusion. Yeah. This is just really just brilliant, man. Yeah. No one's ever tried anything like this ever before. This is a whole new legal world. Someone has really put their thinking hat on big time. I don't know who dreamed this up. But they're much smarter lawyer than me. That's all I have to say. I'm on my best of best days. I could not dream this up. I recognize my own limitations. This is brilliant. This is absolutely brilliant. I don't know who dreamed this up. A statute that regulates or prohibits abortion may not be construed to regulate or repeal any other statute that regulates it. Statute may not be construed to restrict a political subdivision for regulating or prohibiting abortion that's at least stringent as the laws of the state, so political subdivisions have power to pass laws consistent. WikiDIPR gives me $5 to say, it seems like there could be serious problems if the same legal theory were replicated in another context, like weaponized against gun owners. Yeah, you have definitely spotted that problem. You have absolutely spotted that problem. WikiDIPR. I'm not sure whether or not the people that dreamed this up saw that comment. But yeah, well, could you just strike out the word abortion and write in the word gun owners, or, effectively? Probably. I mean, what would be the logic? I mean, you have some Second Amendment arguments, but then again, yeah, it's like, yeah. So yeah, this could be replicated for gun rights if it succeeds in the end. Yeah. Every statute regulates abortion is severable in each of its application to every person and circumstance. Again, with that, like, every case is now effectively non-precedential thing. If any statute regulates or prohibits abortion is found to be unconstitutional, either its face or as applies, then all the applications that do not are severable. And then there's some other stuff with the state and healthy code that says what physicians have to do and blah, 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 some other stuff we don't really care about right now because it doesn't matter. So yeah, basically that's the end of this thing, man. It's absolutely brilliantly constructed. It's brilliantly constructed. Is a self-whittling law designed to unpower itself? I don't know. Well, fine, but someone thought it had. Someone was thinking. This is you don't have a 2A right to sell firearms, just target sellers. That's a little bit like saying you don't have a 1A right to sell books, just target sellers. I mean, the logic, yeah, I mean, obviously the Second Amendment law is broken right now, but it doesn't necessarily flow. $5 from Juan. Thank you for the $5. So, yeah, regardless of what you think of abortion, this is brilliant, and presumably it could be copied and modified into other contexts. And so some states that don't like guns, for example, maybe they can do this. We'll see where it goes. But right now, I mean, who knows what the courts will do in the future, but someone was trying to think ahead. Someone was trying to think of something. So regardless of whether it succeeds or not, they were really trying to think of all the possibilities. So this is pretty brilliant. A couple minutes ago, Cliff Notes version. It's a little hard to give a Cliff Notes version, but I guess the Cliff Notes version is that Texas banned abortion once heartbeats are detected, and they are enforcing that via private action only. So not state officials, but random people who can sue. And they basically did everything possible to make it as difficult for the abortion providers and all the people that help them, and as easy for all the people suing them as possible. So, we'll see. We'll see. Could this be modified to go after people you don't like? 1A, viewpoint discrimination? I don't know. I mean, obviously, I don't know how this could be modified or not. But, once there's an idea, right, I don't know, but it's pretty brilliant. I mean, Matt, no one has, as you are well aware, Matt, no one has ever tried anything like this before. Now you're asking me questions like, could this be modified in other contexts? I don't know, Matt. I haven't been thinking about it long enough. It's brand new law. I haven't been thinking about it long enough. Give me a break. So I don't know. One-way feces violates equal protection. There might be an argument in there somewhere. I'd have to think about it. How does frivolous lawsuits fit into this? I'm not sure that this contemplates such a thing as a frivolous lawsuit. What would a frivolous lawsuit even look like in this context? I'm not even sure what a frivolous lawsuit would theoretically look like. Could you construct a frivolous lawsuit? I mean, I don't even know what that would be. So yeah, it's pretty amazing. It's pretty amazing. There's going to be law review articles written about this for a while. So yeah, if you want the answers to this question, start reading some law reviews. Go to Hein Online and start reading some law reviews about that cite this and see what the discussions look like. If I can ever get my mind around it, maybe I'll try to write a law review article, but right now I don't even know what that would be because this is a mess. I'm not sure, Azeroth. Someone went to a lot of trouble to think about all the things. I mean, there are other examples of one-way fee shifting statutes in other examples. So maybe I just don't know. But yeah, it's brilliant in any case. I'm probably going to be on tomorrow recording some. Tomorrow's a federal holiday, so I'm going to be on tomorrow probably recording, or maybe I'll be playing Mass Effect, one of the two. But we'll see how it goes. But this has been a lot of fun. I hope you had a lot of fun. For the 219 of you who are currently watching, thank you. If you've not done so already, if you could remember to hit the little notification bell, make sure it's selected to all, because YouTube doesn't like me because I discuss things they don't want me to discuss sometimes and try to think about things. I'm going to have to put this on discussion for the legal panel on Wednesday. I'm going to have to send this to Nate Brody and Legal Bites and see if we can dissect this and take another crack at it and see if we can get anywhere with this thing. Because this is a monster. Slap won't work because slap won't work because, first of all, that's for speech, and this has nothing to do with speech. In fact, the law itself was very clear. This doesn't impact speech. So this has nothing to do with slap. Yeah, slap has nothing to do with this. It's totally on here. And even if the fee shifting is unconstitutional, everything else is severable. That's right, Johnny. Which I'm not sure that it is. I'm not sure that it is severable. I'd have to think about it. Because there's other examples, I think, with one-way fee shifting. So I'm not sure it's necessarily unconstitutional. So, but even if it is, it's all compartmentalized. So, it's all compartmentalized. Yeah, we're definitely going to have to give this another go or two to see if we can really understand and poke our head around it. But yeah. Can you theorize how to apply the gun? Not really. No, ASP Atheist. I can't. It's brand new law. I can't really answer these questions because it's brand new. Like, no one has thought of anything like this before. This is something someone dreamed up in a lab somewhere, and I've never seen anything like it before. So, I mean, I'm approaching this for the first time, and normally, my ability to answer questions in law is based on my ability to analogize to the past, right? Because it's common law, and so it's like, how similar is this to what's happened before, and how much can I, sort of make deductions based on things? And this is like, well, this is pretty far afield of what anyone's tried. So I think it's brilliant. It's trying to solve the problems. I don't know if it solves the problems or not. I haven't been thinking about it long enough. Ask me in about 2 years. I'll let you know the answer. But it's like, right now, it's like, well, right now all I'm feeling is out of my depth. Right now all I'm feeling is out of my depth, because whoever wrote this is smarter than me, or at least has been thinking about it longer than me. Either way, I can't play on this. I can't play in this guy's sandbox right now. I can't play in this guy's sandbox. I'm past my limits. I try to be reasonably self-aware, and I'm like, I'm out of my depth right now. I'll give it another couple of cracks. Maybe I'll figure out the answer. Ask me in 6 months. Maybe I'll get somewhere. But I'm reading this for the first time. I'm like, all I can think to myself is, well, this is unlike anything I've ever seen before. It's trying to solve a lot of problems. I think the solutions make sense. I think they'll work. But then again, I've never seen anything like this before. So what the hell do I know? So that's basically where I'm sitting right now. How's that working out for you? It's like I read this. I don't know what the fuck's going on. It's like, I don't know what the fuck is this? Like, it's like, this is. Ask me in a couple months. Maybe I'll get somewhere. But right now, I'm bringing this and I'm like, well, I think it makes sense. I think it works. I think they're writing this. I understand why they're doing it. I mean, I couldn't dream it up. I couldn't dream up anything like this, but at least I kind of understand why they're doing it, I think. And I think it works, maybe, and because here's what's going to happen, and here's how that's going to go in the courts. And now I'm trying to, like, in my mind, project out, like, all these different cases that are coming up in all these courts of appeal that are sort of non-precedential, and how the Texas Supreme Court will look at it, and if federal court will somehow get involved, and I don't even know how that would manifest itself. And you know, it's a lot. It's a lot. Do individuals who bring suit not become state actors? No, they're not state actors. No, the private attorney generals don't become state actors. No. Tall Skinny Geek gives me $5 to say, hidden in the shadows of the shadow of our other rights, the right not to be subject to Meadowbrook. I don't know if it's broken or not. It's just something I haven't seen before, so I'll have to get back to you on that one. Yeah. Couldn't this make the United States a potential defendant for any funding? Well, not the way this is written, I don't think, because at least now money is fungible. So, but at least the way that the federal government gives money right now, the federal government does not fund abortion. There's something called the Hyde Amendment. They're not allowed to. The Hyde Amendment's been law for like ever. So the U.S. government gives money to Planned Parenthood, but not for abortions. So as far as this law is impacting the United States government, no. Because the United States is not aiding and abetting abortions. They're aiding and abetting other things. Now, $5 looks a lot like $5. So there's that. And if you give Planned Parenthood $5 to spend on, say, for example, education relating to contraceptives, then that's $5 of their own money they suddenly were going to spend that they don't have to spend anymore because you just gave them $5. And whatever might they do with that $5, who can say? But yeah, this shouldn't impact the U.S. government because the Hyde Amendment is going to also the U.S. government sovereign immunity. So no, not so much on the U.S. government. No. D. Mary says, you like that I'm discussing it through? Yeah, it's like this trying to understand what the hell this is. It's like, yeah, it's like I don't know if I'm smart enough to play in this sandbox. This is a lot. Yeah, that's right. Abortion provider can't bill the government for an abortion. That's right. Absolutely correct. It's absolutely correct. They can bill the government for lots of other things. And Planned Parenthood does offer services other than abortions. So, you know, they offer other services. So, yeah. Anyways, I'm going to sign off before my brain completely melts. We'll probably get back to this again at some point because trying to figure out what this is. But this was a lot, and I'm definitely going to have to get some other attorneys in the mix and try to. That's the only solution, right? Try to get some other attorneys in the mix, and then we'll all try to puzzle it through together, and maybe we'll come out with an answer on the other end. But right now, I'm kind of there, yeah. So if you're enjoying this legal education content, please remember to hit the notification bell. I'm going to bed now. Good night.